Wednesday, April 3rd. And we today are going to go first with a tax overview, and Chris Ruth is here. And I asked Chris because this is kind of an unusual year. There are several tax proposals that have been attached to the bill that the taxes are intended to fund. Bypass the appropriations process. We've been asked not to do that here, but I thought we should know what taxes were out there and where. So, Chris, the floor is yours.
I'm sure.
Yes.
Just overarching question. So, in this case, are you anticipating that we'll review the tax budget? And then we would do it for folks, but we would then detach that new revenue stream from an application to a particular program.
And that would be my intent. We can tell what we would do. I don't feel qualified to, because I don't know all the requests,
Sure.
to decide what is the most important thing to fund this year. So if we decide to do any of the tax proposals, then we can pull them apart and send them over. I've asked the pro tem to let the chairs of the committees that are receiving these. I think Health and Welfare has one, Judiciary has another. I've asked them to let them know the potential that they don't have any dedicated revenue source. Okay? So Chris, the floor is yours.
Good afternoon, everyone. Thank you, Madam Chair. Chris Rook, Joint Fiscal. In a few minutes, I'm going to be joined with by two of my colleagues who you know well, Ted Barnett and Pat Titterton, who did a lot of the analytical work behind these bills to jump into any questions that get kind of meaty and technical, because I don't want to steal their thunder, and they can give you a better answer than I can. But the chair asked me to come in today and give you all sort of a high level overview of the revenue provisions that are contained in three bills that moved out of the other body recently and are now in various committees in the Senate. I want to just reiterate what the chair said, that this committee does not yet have possession of these bills. But since they do contain some pretty significant revenue items, she thought it would be good to give you all a preview of what those are in anticipation of them maybe coming through your room at some point. So before I really dig into it, Zane was kind enough to print copies and post 4 documents under my name. And I am going to start with a little summary sheet. It is a 1-pager. This is a cheat sheet that you can use to crosswalk what's going on in which of the 3 bills. The full text of the bills are also posted under Kurt Keaton's name, and he's also here if you have legal questions. But I wanted to just start with this 1-page chart to orient you all as to what is in which vehicle, because it can be a little confusing, and I've had trouble keeping track of it over the last couple of weeks, given everything going on. But the first thing I wanted to draw your attention to was there are 2 bills, H721 and H880, that contain the same revenue items in them. The reason being, those revenue items were intended to pay for appropriations contained in both of those bills. So it's sort of helpful to view those as a package deal on those 2 bills. And H721, I'm going to start there. H721 is primarily related to some healthcare expansion proposals, and H880 primarily pertains to investments related to the judiciary. Both of those bills also contain 3 revenue items. The first 2 pertain to corporate income taxes. One of them has to do with what's called subpart F income, which we can get into in a minute. But this item involves what we call GILTI and FDII, which have to do with income that's related to selling intellectual property rights. These provisions would be adding back these items that are currently allowed to be deducted under federal taxes back into the definition of Vermont net income. So by doing that, it doesn't yield any additional money in FY 25, as you'll see, but approximately $15.3 million of additional revenue beginning in FY 26 and beyond. The second item related to corporate income taxes is an increase in the top marginal tax rate from 8.5% to 10%. That is, just to remind the committee, would be on net income attributable to Vermont above $25,000. You get a small amount, $2 million in FY 25 due to some estimated payments likely changing to reflect that higher rate. But again, the big financial gain doesn't kick in until FY 26. That would be about $17.7 million, as you'll see on the chart. The third piece is probably the easiest one for everybody to get their heads around, and that would be increasing securities registration fees. So these are primarily the mutual funds, and DFR collects these fees. This would be an additional $6.2 million a year.
Did we do this one recently?
2022.
That's what I thought.
Yeah.
Okay.
And if the committee, before I move on to the other bill, if you take a look at the fiscal notes that are posted for either 721 or 880, they will start really getting you into the weeds of what these different items are. So I'm looking, just for the sake of simplicity, at the H721 fiscal note on page 4. And this will walk you through sort of a narrative description of what these two corporate changes and the securities registration fee change are. So just to go back to what we're talking about with the subpart F income, that would be at the top of page 4. Right now, federal law allows for 2 deductions related to foreign income that exempts them in part from taxation at the federal level. And since our tax code is connected to the federal, that passes through to Vermont. Federal law currently allows corporations to deduct 50% of global intangible low tax income, called GILTI, and 37.5% of the foreign derived intangible income, FDII. Kirby and Pat would love the opportunity to get into the weeds of what GILTI and FDII are, but I wanted to direct you all to where you can find that sort of narrative description of it.
I'm sure we'll get into the weeds before we finish.
Oh, I'm sure. So what the bills would do is make this effective for tax year 2025, adding back the amount of GILTI and FDII deducted at the federal level. The effect of that would be increasing the reported net income to Vermont. That would be subject to Vermont taxes. So we expect in FY 26, that would generate about $15.3 million of additional revenue. And that estimate incorporates the rate change proposed in section 14 of the bill, which is increasing that top rate on the corporate net income tax from 8.5% to 10%.
Okay,
Which I think is fairly self-explanatory.
yeah, but, and that's anything above 25,000?
That would be on the marginal value above 25,000.
Okay, so essentially it's pretty much everybody.
Well, one thing to keep in mind also, because this often comes up in debate, is when people like to compare top rates from state to state.
Yeah.
Different states do apportionment differently, as you all know. So we have a single sales factor of apportionment, which doesn't really disadvantage somebody who's headquartered in Vermont versus somebody who's headquartered elsewhere, because the taxes are based on how much of your sales activity is attributable to Vermont, rather than where your property and payroll are based, which was part of the way the old way was before things were changed a few
And we
years ago.
did that, I think, in 22.
It was around then, yeah, it was a couple years back, yep. And then the third piece, the securities registration fees, you'll see at the bottom of page 4, it's fairly straightforward, the underlying math behind that fiscal estimate. So the language in the bills would propose increasing, most of the money would come from increasing the renewal fees that are paid largely by mutual funds. by about $250 a year. And you can see that almost 22,000 filers renew in 2022. So that's a fairly robust base of payers.
But I think we also don't want to get out of line nationally, because I remember we were up there when we played in this.
Yeah, you're up there.
Yeah.
And you know, it's also when you're dealing with securities, it's important to keep magnitude in mind too, because a lot of these funds that pay this, you know, have hundreds of millions of dollars of assets. So when you look at their administrative fees from year to year, it can be relatively small, but you know, your point is well taken that, you know, you want to, there's a compelling public policy interest to make sure your fees are not an outlier.
Okay, yes.
So the first go round on this was Senator Sorokin. Isn't that where that came from?
I remember we went after, you know, we did this fee like the last week of the session when we needed a couple $1,000 or something to balance the budget. This, I remember doing it, and going over the whole list of fees and ones that, you know, had been done recently, but as I remembered, it was to get budget in balance.
So I am going to, just in the interest of the committee's time, largely gloss over the 880 fiscal note because the fiscal impacts of the tax changes are largely the same as what I just talked about. The one thing I did want to draw attention to in 880 though is there are, and this will, assuming that the Judiciary Committee does something with this bill and sends it your way, there is a change to the allocation of Judicial Bureau surcharge revenue included in the bill. So this is not a sort of big picture, raise millions of dollars kind of thing. What this is largely a technical correction. So the committee might be aware that on criminal violations and civil judgments, the Judicial Bureau tacks on a $47 surcharge. That $47 surcharge is apportioned to the funds that are run by the Center for Crime Victim Services. So the Victims Compensation Special Fund and the Domestic and Sexual Violence Special Fund. These funds have had a well-documented decline in revenues in recent years because there just aren't as many violations being issued or making their way through the court system as there used to be. Last year's big bill, Act 78, changed the allocation of that revenue to direct more of the money into the two special funds out of the 725 that used to go to the general fund. So they basically took that 725 and divvied it up between the two special funds. There was an issue though with how the language was drafted. It inadvertently made that split retroactive to 2009, which, yeah, so that was flagged as,
Left out of one.
well, it was flagged as not being administratively actionable the way it was currently drafted. So what this language does is not deviate from the intent that the legislature had previously enacted in Act 78, but it rectifies some of those administrative problems by not making it retroactive that far, but make the split apply to violations that were incurred beginning in FY24 moving forward. So this is not a significant departure of policy. It really doesn't change the revenue situation as you all had envisioned it being when you passed the Act 78, the FY24 big bill.
Yeah.
But it makes some changes to make it so your intent can actually be actualized.
Okay,
That would have a relatively small in the big picture benefit to those two special funds that we've articulated here. Obviously, there's a range of estimate here based on how many violations are going through the system. But we would expect that the Victims Compensation Special Fund would see increased revenues by between 132 and 255,000 a year. And the Domestic and Sexual Violence Special Fund would see an increase between 123,000 and 238,000. The general fund would see a proportionate reduction between 255 and 493,000. So you're just dropping that money that would otherwise go to the general fund and instead splitting it to those two court funds, court-related funds. So I'm not sure if the committee is really interested in looking at the appropriation side of what was contained in these bills, but the fiscal notes do give you a high-level overview of what these funds were intended to pay for. You'll see on the back of the 880 fiscal note a table that summarizes all the judiciary appropriations, $7.5 million appropriated in FY 25, paid for by these three things we had been talking about. And the prior fiscal note for 721 gives you extensive detail about the different healthcare related investments that would be funded from some of these additional corporate tax changes and securities fees as well. I'm then going to move to the third bill, H 829, which if you go back to the summary chart, it will show this one, here, all of the tax packages are just in this bill. We don't have two bills with the same tax things to pay for both. Here, it's sort of one tight buttoned up package. 829 is primarily a housing bill, and it includes two significant tax changes that would pertain to property transfer tax and the personal income tax. The first one the first item dealing with the property transfer tax makes extensive changes to the tax as compared to what we currently have, and would generate $17.5 million of additional revenue beginning in FY 25 and then carrying forward into future years. So to make a long story short, the property tax for tax changes involve increasing the threshold for principal residences at which the 1.25% applies. So if you remember under current law, I believe it's the first 100,000 doesn't pay the 1.25 of value does not pay that 1.25%. This would increase that threshold for principal residences. So it would create sort of a larger value of exemption on principal residences.
$100,000 house, when we did this, is now probably closer to a $500,000 house, same house.
Right, and the brackets in this also, I believe, have an inflationary escalator moving forward too, so they wouldn't be set statically in statute. The biggest change in the property transfer tax though, which really yields that 17.5 million of net new revenue, is by putting in 3.65% tax on marginal values greater than $750,000.
I assume Ledge Council is gonna tell us how they define principal residences, because we had a pretty clean solution that I believe the tax commissioner said was possible. My understanding was the chair of Ways and Means didn't think we could focus on principal residences versus second homes, non-primary residences, so.
I'm gonna look to my colleague in the, if you don't mind, Madam Chair.
When we get.
May I phone a friend?
No, we can talk to Kirby about.
Yeah, and the tax commissioner is coming in to talk about the Be Home bill.
Yeah,
And I think this would be another one, I'm sure the realtors are gonna wanna talk about it. And in the home bill, we did it as,
we doubled the, just the property transfer tax
Right.
for not the clean water surcharge. So it was 2.5% if you do not file a landlord certificate or a homestead declaration. At 3.65% tax above the value of $750,000. I don't see, it raises almost the same amount of money, and I think it does it in a less beneficial way to actual Vermonters trying to buy.
we will, you don't want to hit. The tax commissioner today, when I told him we wanted to talk about second homes. I guess there's a huge study coming out next December, but that some primary residences are on farms and they're listed as commercial
Mhm,
as a farm.
mhm.
So, I guess that's part
Yeah.
of what they're trying to work out. But this one is the property transfer tax. You do it at closing, you know what you're.
Exactly,
selling.
so discrete number
So
of
that
transactions.
we can work on and,
Right.
we'll flip a coin and see where we come out, how much we raise and who we raise it on.
I just I want both sides of that coin to be the same, because I just think this is, I really can't support this proposal. Just a tax on homes above a certain price, because that hits population centers extremely hard. And it hits primary home purchasers hard.
Okay.
They're the ones who pay it.
We will look at.
Yeah.
Okay.
And Madam Chair, it might help the committee because this is such a big and easily confusing topic. If you look at the fiscal note for 829 and go to page 3. There's a table at the bottom that summarizes the different, these are the changes that are envisioned in the bill for the different value thresholds and different property types. So hopefully that's easier for the community to get their head around than trying to listen to my garbled train of thought.
Which one?
The fiscal note for 829, page 3.
Mm,
And you'll notice that the clean water surcharge, I didn't want to forget that, would increase from 0.2% to 0.22%. And that is to basically make the clean water fund whole, because by making some of these other exemptions, increasing the threshold values at the lower end, it would have reduced the amount of revenue going into the clean water fund.
Okay.
The last item I wanted to draw the committee's attention to today had to do with, well, I should say there's 2 other things I wanted to just mention briefly. And this is at the bottom of page 4 of that fiscal note. The bill does include 2 other property transfer tax related items. One would exempt transfers of abandoned properties if the property is rehabbed and used as a principal residence within 3 years of the transfer. This is more limited than what the administration had proposed in its budget of in the GovRec for FY25. I believe their initial proposal would have pertained to blighted properties, which would have been a broader universe. And there were a couple other differences that would have resulted in a higher amount of revenue loss than this more narrowly tailored provision would. We do not expect there will be lots of properties that would be subject to, that would fall within this exemption. So it's a little hard to get our head around just how much revenue loss that would be, but we don't think it will be very significant. There's another, at the very, very bottom of page 4, exemption for transfers of a new energy efficient mobile home from the property transfer tax. The number of transfers of new mobile homes that are currently assessed the property transfer tax is rather limited. So we don't expect that will lead to a very large revenue hit either compared to current law.
Just a quick question. I think I know the answer, but I may be wrong. Go back to page 3. When you talk about the marginal value greater than 750,000 for non-principal residents, I'm assuming that the tax rate, 3.65%, only applies to the difference between 750 and the
Exactly.
whatever the number is.
Exactly.
Right? There's tax at the same rate on the first 750.
Right, it would work like your personal income
Yeah,
tax.
yeah.
So if you have an $800,000 property, it wouldn't be 3.65% on 800,000. It would be on that $50,000 above the 750.
This is really helpful, Chris. I'm trying to piece together I'm really on the H880 and this H721. And as I'm looking at trying to correlate the two, I see H880 as having a $7.5 million cost for just FY25. I don't see projections out 26 and 27. I do see those for H721. But even when I connect the 2 of those, I see both of them raising 40 million, but the combining of the costs of H880 and 721 maxing out 2 years out at about just under 30 million. So is my math wrong, or is this raising 10 million more than it's proposed?
It raises a little bit more next year, and something that I want to sort of stress to everybody is, the appropriations for years beyond FY twenty-six are legislative intent that were expressed by the other body. This is sort of my standard disclaimer to anybody watching that you all appropriate on a one-year basis. You can't find future legislatures, so the best laid plans ultimately depend on the actions of who's gonna be here next year. But I think the intent here was to create a package that would basically pay for the contemplated investments in both bills with the understanding that there's a little bit of unknown about what future annualized costs might be. And that's what we'll have an FY twenty-six budget process to suss out. And some of the, it was mentioned in one of the notes that some of the additional revenue, it's in the housing one, would also be to support temporary emergency housing as well, not just the strategic investments that are appropriated.
Thank you.
The last really fun and exciting topic I wanted to touch on in 829 has to do with the personal income tax. And this is on page 5 of the 829 fiscal note. 829 would add a new top marginal bracket and tax rate for all filing statuses under the personal income tax. This top bracket would be 11.75%, so it would be 3% more than the current top bracket. That is expected to yield about just under $75 million of additional revenue beginning in FY twenty-six. So out of all the revenue items that are in these three bills, this one raises the most. And you can see these tables here will show you the breakout of what those adjusted gross income thresholds would be based on filing status. So if you're married filing jointly, that would kick in at $500,000 of AGI and above. And just like Senator Brock mentioned with the property transfer tax, if you earned $501,000, the $1,000 would be subject to the 11.75, not the entire amount.
Senator Chin.
I know we're looking only 1 year out because things change. I'm curious in the modeling, if there's anticipated diminishing returns, looking at what we would expect 2, 3, 4 years out. As I recall, reading an article that in the House testimony, they did give testimony that anticipated 17% of people might flee the state or this tax jurisdiction based on estimates from before the pandemic. Do you know if that 74.9 million is expected to decline years out, or is that beyond the scope of your analysis?
I'm going to phone a friend who actually did the analysis, my colleague Pat Titterton, if he has anything to add.
Pat?
Yeah, so Patrick Titterton joined fiscal office. I guess just to keep it somewhat concise, we are incorporating expected behavioral changes. What we're relying on here are some academic studies, one relating to California, which had done a similar top marginal new bracket increase back in like 2012. And we're also relying on some information from Massachusetts, which recently implemented the millionaire's tax, which is 4% above $1 million. And so what the literature, a lot of it shows is that rather than the biggest influence coming from people moving out of state, it's more the larger chunk comes from behavioral change.
Exactly.
So when you sell assets, when you deem certain income, seems to have a larger driving effect. So we have incorporated a pretty sort of conservative, meaning hefty adjustment for expected behavioral change.
Really quick, when did Massachusetts implement the millionaire tax?
So it's just coming into effect. So it's a couple of years ago they implemented it, but it's sort of bad practice to implement tax changes in the same year that you're in. So we'll just start seeing the results flowing in. But initially they were estimating about 2 billion. That was a static analysis, meaning no behavioral change. Some estimates later came out at around like 1.2, 1.3 billion after factoring that in. And where their legislature eventually ended up, so what they're expecting for revenue is about 1.5. So it's about right there, that's like a 25% discount right off the bat.
We'll get into all of this much more deeply.
Well,
Bring your hips.
Can I ask one more quick question?
So with that very large amount in FY '26, I'm having trouble telling if they even attempted to tie that to certain uses.
They did, in FY '26, the general fund this is actually on the first page of the fiscal note for 29.
Okay.
The general fund would receive, just under $41 million after the intended appropriations, the strategic housing investments that are contemplated in the bill. Again, subject to the appropriation decisions of you all next year. But the intent would be to, use that just under $41 million of additional revenue to pay for, temporary and emergency housing.
Have we done that before? I mean, try to budget the use of a new revenue source?
Well, this is just an expressed legislative intent. So
Right,
we're
but,
not
I mean-
building a budget for '26,
Have we expressed our intent that way in the past?
I don't know, this committee, I can't ever remember. We were asked to find a source for the clean water fund before
right.
the feds took over.
Right.
And we did that, but generally we respond to a request from appropriations.
Right.
They find out how much they need, they tell us, and we raise it. I can't remember, but a lot of bills come in with money attached.
Right.
This is the most massive,
Yeah,
kind of raising a lot of money with a lot of taxes for a very dedicated purpose. Yeah, I found it interesting, we're talking about the courts. They're struggling across the hall to get enough judges so the courts can function. And, you know, for us to make appropriations decisions, we just don't have the information. So
yeah. Madam Chair, I think the one, and you all have far longer institutional memories than I do. I can think of some examples when I've been here where the legislature has expressed intent to make financial decisions in the future, not quite on this scale, but I can think of some things related to pensions that you all have expressed intent to take a future action and sort of fence money aside to fund that future action. I think the one thing to be mindful of here is, you know, I think this was intent to clearly express the germaneness of the revenue package to the contemplated uses of the revenue as this being sort of all related to housing.
Yeah.
Ultimately, it would be up to you all, or whoever's here next year to decide, do we still need $40.7 million for temporary emergency housing next year? Or maybe
Right.
you use some of that money for other strategic investments.
Well, right, I mean, I guess that piece of, like, obviously in this committee, we'd be looking at the tax and deciding whether there's merit to that kind of tax. But it's a policy discussion in the housing committee, and then obviously an appropriations decision about whether we would even want to have that intent. So we might be looking at tax increases. I don't think we should be doing them in the context of what they're for.
it would be rare unless we
Yeah.
were asked to do so by the appropriations committee. So you don't.
Act 60 started 6 months to raise money 6 months before the year in which the bill was implemented.
Yeah.
So
Yeah,
that was
we
the case.
frequently do that.
But steering within the general fund toward one purpose seems to be
Yeah.
different than this goes to the education fund.
Okay.
That's all I've got, Madam Chair. So if you all have any other questions, I'm happy to answer them.
Given us enough to look at, I think what we'll do is just start looking at the details of each one. Probably starting numerical order and ending up at 829. Right, well, we've got one thing before that. So, we'll work our way through these. Anybody that has anyone want to have testify. I did have a call from somebody from the tax. It's one of the national tax organizations. I told them everybody is welcome to speak, so I will, Dane has the credentials and I'll give them a call. I know public assets, did they want to testify on any of these bills or?
I will chat with our executive director.
Yeah, I think they do. Because I think there is an increase in the income tax, not a surcharge, but a high bracket, which may, serve the same purpose.
Clarification, we don't have these bills, they're in the committee's jurisdiction.
They're in the committees of jurisdiction. I've asked the pro tem and I will check to make sure that the committees know that if they go to appropriations, they're gonna strip out the taxes anyway.
And the appropriate.
Yeah, the appropriations, we get them afterwards, but, I want them to know that just like if we were raising the taxes and they were sending a bill, they don't have a guaranteed funding stream coming in. And that's the one thing we've been asked not to do this year is guaranteed funding streams. Okay. All right,
Before I go to the chair, Madam Chair,
Yeah.
I just wanted to draw your attention to the fact that on the header of all of these fiscal notes, you tend to see more names than you typically see. These
Yeah.
bills have been a tremendous team effort, with all of our analysts at JFO as well as, with Ledge Council. So I just wanted to publicly acknowledge and thank, Ted, Kirby, Pat and Emily for all of their hard work on this. These were very, very big legislative packages to cost out without a lot of time to do it. So I just wanted to give them, even though I'm the one sitting in the chair stealing their thunder, I wanted to give them credit for all the hard.
we'll have them all back to thunder as we go through these bills. As I heard the chair of Ways and Means talking about what she was doing and I was wondering who was doing all of it for her.
We've all earned some future days off this summer.
Good, maybe we get one for the eclipse. Only if it's sun, you don't wanna waste the day off the eclipse. Okay, thank you.
Thank you.
Committee. Okay. We have got 50 minutes. Before we're going to hear from the league and from the listers, and we have Carol Hammond, who is chair of the board of listers, but also the person, I got another email that said it was supposed to go to all of you today. I guess there's a concern about dams or dam, but it said hydro, and I had to call in to property valuation, but the tax commissioner came in. He's reminded us that generation facilities, hydro facilities are not included in this bill. So I hope that solves that problem. But I did hear from Vermont Electric Co-op, Andrea Cohen, they support going to a state.
Madam Chair, can I ask a process question? I mean, I spoke to the particular tax that I think we have an alternative proposal that we're looking at.
Well, there's one attached to the House bill that is in. Actual resources, we will look at that.
Yeah, I mean, I wonder if there are certain proposals. Once we understand what they do, we want to decide whether or not we have a parade of people coming in to say whether or not they support it, because that might just waste it.
I'm not, no, I'm not playing, having a parade.
Okay.
I don't have that time.
Yeah,
We will have 1 or 2 representatives.
okay,
And we will have more if we have time.
yeah,
We will definitely have the list, the realtors in, because I know they're very front row on this one.
Your next witness has joined.
Our next witness has joined us, so we can move forward. Anyway, we will, get both of those. Do Kirby drafted both of them? Okay, should we, maybe draft?
Yes, yeah.
Okay, maybe we'll set you up maybe Friday or next week and we'll
That sounds good.
do it side by side.
I'm also available one-on-one.
Yeah.
If you need.
Well, yeah,
Yeah,
I think we know what's in both bills, but the rest of the committee.
Right.
Except maybe Senator Brock
Right.
doesn't. So we will put both proposals up
yeah.
and see where they go. Okay, we're gonna move on because our witness has arrived. This is, again, section 8 of the miscellaneous of the act related to administrative and policy changes to tax laws. Section 8 is the one that would have the state do the appraisal of electric utilities. So Carol Hammond is here. Carol, you can zoom in. Carol is from Vernon, which asked, this is a question. Maybe she is not. Here she is. Yeah, there we go. Hi, Carol.
Hello.
Okay, we just need you to introduce yourself for the record and then the floor is yours.
Okay. My name is Carol Hammond. I'm the chair of the Vernon Lister Board. And I am testifying today as to the effect of H 546 that will have on our towns in the state of Vermont. Shall I continue?
Yes. Floor is
Okay.
yours.
All right. As listers, we take an oath to appraise property at fair market value. We take that oath very seriously. This bill will remove the valuation of utilities from the municipalities. And the oath that we take would become meaningless because there would be a whole segment of the properties here in town and in other towns that we would no longer be allowed to appraise at fair market value. It's for the loss of local control. When we sign the 411 form and give it and the grand list to our town clerk, we have to certify that this is a true abstract of the grand list. How can we certify what we have not determined? Our town attorney told us many years ago that the way that the utilities they submitted their values, which the state accepted, that really was not constitutional. And because we swear an oath to appraise property at fair market value, and this was not the case. So we set up a fund here in our town to take care of the cost of an appraiser and legal advice for all of our utilities. I've been a lister for 27 years. We've been through appraisals, many appeals, litigations, and have dealt with the utilities many times during that time period. Historically, they undervalue their properties. Case in point, as I put in my email yesterday, if we had used Great River Hydro's values from 2020 to 2024, we would have lost over $40 million in tax revenue to our town. This, of course, would also be a loss in tax revenue to the state education fund. And one thing that we are very concerned about as listers is we have not been part in any way of the conversation that the state hired appraiser has had. He's only met with utilities, and we've had absolutely no say, no input into this. Well, putting this bill, putting the language into this bill, and this is a lack of transparency. as well as a lack of professional courtesy to the listers of the state of Vermont. What we would recommend that this bill should only require a state advisory, a state advisory board, or whatever you want to call it, where the values that would be made by the state, that they would be advisory only, and that the listers in various towns could either use these values or have a outside appraiser who sets the values. It should not be mandatory. This should be advisory. And then a town, and I believe this is done in the state of New York, that a town can ask the advisory board for value, or they can set their own. If this was set up at a state advisory, then the state would be responsible to defend the values, including all costs. If they lose, then they'd be required to reimburse the town the taxes, at least the school portion. That's one thing to remember, that the cost of the state would have to defend these values and should reimburse the town for lost taxes. Because then the burden of proof does shift to the state. And if this is the case, then we would, as on the local level, we would have no control over our budgets, because we would not know what these values are, or how these values are going to be set. And this is another thing. There's nothing that, at least that I could find, where there is an explanation of the methodology that's going to be used. We have worked with an outside appraiser since the 1980s, and we have worked with this. Let's see, he's only the second company that we have worked with, and it's been a good working relationship, and we feel that the values that are set, they are fair market values, and we do not want to lose that ability to do that kind of, to do those appraisals, and to protect our town as far as our revenue. And I know something was mentioned about Section 13 in this bill, that the towns could basically find other ways to tax people. And, local option tax in rural towns, that just didn't even make sense. And that had nothing to do with the state appraising utilities. We feel it's a bad bill, that it's been poorly conceived, poorly thought out, and that there will be unintended consequences if this bill is put through. And another thing I would like to mention is that if the utilities, if a value is set and the utilities appeal, and if the state lowers the value, then the state of Vermont is going to still want X number of dollars to pay their bills. Then the burden falls, not the burden of the shift falls to the homeowners, to just the regular homeowners in this state. It would shift from the utility section to the homeowners. And we do not feel that is just wrong. Another thing that is of concern is the the ability of the town to appeal a value that is set. It sounds like in the bill that the director's decision is final, that we would have no appeal, and that is wrong as well. That is basically my concerns and my recommendations.
Senator Bray has a question.
Well, I think I want to start with one for the chair before going to our
Okay.
guest. Can you remind me of where this language?
It's section 18 of the miscellaneous tax bill. And there's another bill that the House passed that does similar things, but I think.
Right, so, as I'm finding in H 546, section 9, property tax exemption, then there's a,
No.
No, it's
and then the next-
it's utility valuation.
I'm sorry,
Section
section 8. What's the page, 5 and 6, yeah.
Yeah,
So,
section.
Page 6, okay, I just didn't know, whose language it is, and if they have come in yet to.
This
explain.
is Ways and Means language.
Okay.
It's their bill.
But is it the governor, is it the governor's? It's the
This
governor's.
is what Abby spoke to yesterday.
Yeah,
Okay,
Okay, I just want.
I wasn't there either.
The origin.
yeah.
Alright. Okay, well, that would explain maybe not, and so to our guest, Ms. Hammond, thank you for coming, and, did you speak at all with Ways and Means when they were working on this language?
No, I did not.
What's that?
okay.
Think, and the other thing, when you were talking about, you have that special situation down there with dams, but to be clear, this was only gonna be applied to, transmission and distribution, not the value of a
Right.
hydro facility.
The hydro generation is excluded from this bill, so you don't have to worry about the $31 million in, this is poles and wires. Which generally are a very big part of the grand list.
So that would still affect Velco. That would
Yes,
affect New England Power.
yep. And when I was in city government many years ago doing budgets, and how you evaluated poles and wires, really you had to hire a specialized appraiser. And for small towns, that's an expense, and I think the hope was to take that burden off of the towns. It's usually not a big part of your grand list. And help you do that. You're still gonna have to fight it out with the dams.
Well, our town put aside money. We had a fund established to take care of the
Right.
appraisal as well as the legal advice that we needed to appraise those. So,
So now you'll just have to approve the dam. I doubt that your bill's gonna be down very much. But you're still gonna have to appraise the dam. It's just the wires running down the street on the poles.
If-
It's the poles and wires that bring your cable TV and your electricity to the homes, to the businesses. That's what the state is going to appraise.
well,
Yes. Thank you. I'm just moving a blockage to my view of you.
that still generates a lot of value, a lot of tax value to the town,
Oh,
and to the
we
state.
will look at that, but that's, that's a very technical thing. I don't think anybody intends to take any money away from the towns. We're hoping to save you some money because you won't have to, well, most towns don't have a hydro dam. So we're hoping to save the towns some money. But we will definitely check with property valuation and make sure that they're not anticipating major changes in your values.
Then why do they, I guess I don't understand what you're saying. We, if we are willing to foot the bill, which we have done for many, many years, why wouldn't an advisory committee, why wouldn't that be better so that the towns could choose? If we choose to pay our own bills, then why would not, I mean,
I think because appraising poles and wires is not something your average lister does. It's a specialized skill. And rather than have 35 different towns with 35 different appraisers valuing things slightly differently, it would be easier for the utilities that go through towns to know what their rate is in every town. So that there's some consistency, it makes it easier for everyone's finances. And it shouldn't hurt yours, it should allow you to only have to contract for your dams.
okay, then why were not the towns included in the conversations between the hired appraiser? Why were these meetings only with the companies? Why were not the listers included in these conversations?
We don't control that, I don't know if I can get anyone from the tax department, do you know why?
Jill Remick, Director of Property Evaluation and Review. I've provided a pretty regular update at the Vermont Assessors and Listers Association. And we did do a public bidding process to choose Brian Fogg Associates as our valuation expert.
Okay, so they did do regular updates to the Listers Association, and we have Lisa Wright here, who is president of the Listers, so they've been kept appraised. But I don't know how they communicate with you. But it hasn't been done in secret, at least. I've got a couple questions here. I'm gonna go to Senator Bray and then Senator Chin.
So, you're saying the language that I was referring to, just in case, I don't know if you have exactly the bill we have, it's on our website, but page 546, page 7 of 17, and the narrowing of what the valuation is applied to is on lines 10 through 13. Then the quick question I have for you is there, you were saying something about it seemed problematic for you to, attest to like kind of an oath that you're including all the proper values on your report as a lister. Are you suggesting that language, that legal language would have to change in order to accommodate, say this went through, that you would have to change that attestation to include that you could also be accepting a value determined by the state, not by you and your lister colleagues? Does that make sense?
I hear what you're saying, but to me, I mean, I guess I don't know how to answer that.
Okay, well, I know that this doesn't sound like something you would like to see happen. I'm just saying, do you have a form you sign that is incompatible with this? Are you accepting a value that someone other than you and your colleagues as listers have put onto that form?
Well, yeah, I think it would be a problem if we haven't determined the value or we haven't used, our the appraiser that we use for determining these values, and we agree with his values, then I don't see why we would have. I guess I wouldn't want to see the oath changed, because we should be able to maintain our own grand list on the local level.
Absolutely.
And we should not have to agree with someone from the state saying this is the value. I mean, I wouldn't cite it.
Okay, so we can see about changing the oath. So that But
No, I don't think that's necessary. I think leave the assessment of the utilities at the local level.
I don't think that's going to happen.
Then I just hope that whoever makes the final decision on this has looked down the road at any unintended consequences that this is going to cause.
Okay, I think that's our job. We're looking at it. I don't think there's any intent that you should lose any significant amount of money. It's not, check what your valuation is for your poles and wires. Because, and they need consistency. They run through all the towns and it just makes that easier. Senator Chitty.
Somewhat on that line, I'm wondering if, Carol, you might speak to, do you see any possible upside benefits regarding freeing up time of appraisers in the state and listers in the state? Is there some merit to the notion of not having this be on your docket and allowing for more capacity to look at commercial properties and housing? Or is that a moot point?
I think that's a moot point because I think that right now, I don't see any upside to it. It's more loss of local control. It is more controlled by the state over the towns. And this is the right of the listers in each town to value their properties. And this is not a purview of the state.
Okay. We can see if we can get a legal opinion on that. We've got the league coming in next. So we'll ask them what their opinion is, if this is taking over the town's authority. Okay, and you're welcome to listen in.
Okay.
Okay, and just stay tuned. Do we have Ken is not right, but Lisa has. So if Lisa can tune in.
So do I just mute my mic?
Yeah, you just mute, you'll be fine.
Okay.
Okay, there's Lisa. Lisa, thank you for joining us. Just wanted to get the opinion of the Listers Association, and it's been brought up. I don't know if it's for you or that we are usurping town power. But just want to get the opinion of the listers, pro, con, whatever.
Okay, good afternoon, everyone. I will try to answer as best I can. I try to be really careful about stating what the value or what the VALA opinion is without coloring it with my own, and try to disclose which opinion I am presenting. So we do have some VALA consensus on this issue, but it is not universal. It's always hard to get consensus because our job is to weigh all of the facts and present an informed opinion on appraisal. And so we will have different opinions. And as long as we're doing due diligence and presenting defensible values, I think we should be continue to be given the reins to do that, and do that as we have been trained to do properly. So that said, there does seem to be consensus among VALA about a significant concern with the lister oath that we are signing to values over which we have no control, no appeal options, as I understand it, if this bill passes. If we don't accept those values, the town can't appeal them, and we're signing that as listers with our lister oath and with signing the grand list. And I think we almost universally find that problematic.
Are you trained to evaluate poles and wires? Is that something that comes in your training? In my day, we always had to hire out to a specialized lister.
No, what's traditionally been done, and I don't know what this committee has been told about this, but I'm getting the impression that you've been told that a lot of listers are doing that on their own. I don't know of a single town that is doing that. Maybe PVR has documentation of that, but I find it's either one of two scenarios in towns in Vermont. Either they accept the inventory values from the state of Vermont, PVR, which are advisory at this point, or they hire a qualified utility appraiser to appraise those properties. Agreed. I am a licensed residential appraiser. I am not qualified to appraise utility properties. But I am qualified to know what I don't know and when I need to refer out to other sources that do know.
Okay, so I think the proposal here is that PBR will do that. You won't have to hire out, so it'll save the town some money. And you will get, and if it's our appraisal, I'm assuming, and I'll check it with the commissioner, that we will have to defend it. If we're doing the appraisal, what we can do about your oath. I'm not clear why being able to swear to the lister you hired as true, but not feeling you can do that with the state's appraiser, that we're basically hiring for you. So I thought this was to get some consistency for the utilities amongst the towns and kind of save the town some money.
I understand that that's what you've been presented with. I don't agree with that personally, and I believe we have consensus, at least among our legislative committee of VALA, that we are concerned about unintended consequences, that it will not pan out to be a win. And I'm prepared to present that. If you want me to go now, or I understood that Ted was on next, or.
What kind of unintended consequences are you anticipating?
Well, so let's take this to its logical conclusion. These values become mandatory. So we can't defend them because they're not our values in our town. So the state is going to have to pay for the defense of those values. And it will be a lot easier for the utilities to grieve and appeal those values because they'll have one entity to deal with, the state. And they will go after this. This is what's happened in other states. I have this in my presentation. You should research that. Other states that have made these values mandatory and put it under the state's purview have ended up with net book values when it's all said and done. That's the unintended consequence. Is the state prepared to go through what you'd have to go through to defend those values with such deep-pocketed taxpayers?
Okay, maybe we'll see if somebody from the tax department would like to come up. Yeah,
Is Lisa fine?
well, just has property valuation, has the tax department thought this through, unintended consequences?
Yeah, Jill Remick, Director of Property Valuation and Review of the Tax Department. The contractor that the state has contracted with, has defended multiple valuations, around New England. We definitely share the concerns that you folks have heard, that the prior values and the values that are submitted may be low. And often, I think Lisa and Carol are absolutely right that what we have seen and why we presented to the legislature back in 2021, we did a pretty in-depth report about exactly this issue, is that the values that we were providing were low, and that when the towns were hiring and litigating and defending those values, that there was some progress made in those overall valuations. Not always and not universally, and very expensive and litigious. But that is why we've spent the last couple of years working to build a new valuation model. So I think these folks are absolutely right. If we were just systems as they have been in the past and accepting values from a utility at face value, then that would be problematic. But this is partnering with us working with an expert in this particular, which is sort of a unique skill set. His name is Brian Fogg, out of New Hampshire. That is exactly why we contracted with someone at this level, that they would be able to participate in court. They would be able to participate in defending the valuation. And on behalf of the state, and it would be one methodology statewide.
Okay, so the risk is on us rather than on the town. Okay. What about their oath? Can we reword that?
Yeah, I find that interesting. I'm gonna have to take another look at it. There are actually a lot of properties that are already dictated to some extent or another. There's also lots of exemptions. There's valuations for certain types of properties. There are other utilities that already have a formulaic value that's provided. So I don't think that's insurmountable, but I understand that perspective. I think it's really important to remember that these values are also for the education grand list, and that's why the state has a vested interest in this.
Okay. So,
In the event that the state assumes this responsibility and there is a loss in court in which the valuation is lower than the valuation that the town, based on the state's instruction and the state's system, in other words, the system that's being proposed, who suffers the loss and has to pay it back? Does the state or does the town?
Similar to what we already do currently for hydros, the Attorney General's office does get an annual appropriation. They have an attorney who defends those, and the state does have a contract with someone who's a hydro expert. So I would assume it would be that same.
Well, I just
Financial
recalling having run into this in the past, I thought that there was only a certain amount of money allocated each year for that purpose. And I recall town of Sheldon in particular, where this happened, at that time, there was a substantial amount of overage that was still left. And what we wound up doing is having to pass a special piece of legislation in order to make that happen. And there's obviously no guarantee of that. And I think what I'm hearing from the towns is that if the state is going to take over the responsibility and the ability to do this kind of appraisal, that they ought to be responsible for the results if the results are bad.
we do have a fund, right? And
Yeah.
I thought it was 100.
With it's 100,000 now, it used to be
Yeah,
less than
I
that.
thought.
It's gotten increased to 1 million for exactly
Yeah.
this reason.
Yeah.
So what it does is it
We did that.
reimburses the town.
We did, I know we
Last
increased
year.
it, yeah.
It was from that case that you're.
Yeah, it was a Sheldon case, yeah.
Yeah, so there is money available and we can always make more, and that will make up the difference in the grand list, right? If we do the appraisal, they take it at face value, we lose in court. I think the question is the state gonna make up that difference in the grand list
For the education fund.
for the education fund?
But not for the town, what the town in law would lose, is that right? They just do the education fund?
I think it's important to remember too, we do in our utility report from 2021, there was also a Supreme Court decision that articulated the problems of our current structure. That it is this sort of patchwork of litigation that may or may not be successful. And unfortunately, there are several examples where towns have had to defend and litigate and assess, which is very costly. Some towns may choose not to. And then not necessarily prevail or settle for a much lower amount for a long period of time. So it's very,
That's
It's
the other
not
issue
even-
that we saw in looking at other cases like Sheldon, is there were some towns that were simply adverse to litigation because they recognized it's a small town. They couldn't afford to litigate this to defend what they had believed to be the right thing to do. And as a result, there was no backstop for that.
Because.
And I'm gathering that you would be, by doing it at the state level, there would be a backstop and sufficient resources to follow the litigation to the end in order to protect those values. The only thing, though, that seems to be missing is that in the event that the responsibility is taken by the state to do it, there's no guarantee and there's no backstop in the event that you lose and the town money as opposed to the education money is put at risk and that gets lost. Now, obviously, and again, that'd be something to talk about, if there's the idea to go ahead with this, it may be to just take a look at the backstop fund and see that it in effect acts as an insurance policy for everything, if we're depending upon the state to do the valuation.
Okay.
That the state takes that risk.
Right, we will. Joe, you can come in that sometime or somebody and talk to us about the backstop, about the system. We did heard a lot of this with Cambridge and the timeshares. And that was when I think we increased that backstop money. But,
I think it's important to remember too, that that situation happens now.
yes,
And at least in this case, we would have our state appraisal who we've contracted with, we have the Attorney General's office, we would have a pretty
We'd have
robust
more.
ability to, you know.
we're definitely
articulate our
more
position.
robust than a town of 200 people.
But you can still lose. I mean,
Yes, maybe we're wrong.
and the issue that I'd be concerned about is that if the state takes us over, the state loses, that with the town, which doesn't have any ability to control the appraisal, or for that matter, to negotiate it, I gather at that point, that they don't get put in a position that they've got to accept
Right.
the full loss if that happens.
So we will look at that. Okay, so anything you can bring back to us would be helpful. Okay. Ted Brady has arrived. Ted, come on up. You've got a nice chair for witnesses,
So much.
better than you find this with the other rooms.
Yeah, just over and go out, so here's not quite as comfortable.
No, I think that was the last one I remember sitting. in.
That's the limit,
Pretty
yeah.
rough.
Yeah, right.
Okay. So, what does the league think of this? We've been told you're usurping town rights. Does the league as a whole have any opinion, and what's the general consensus is in this one?
The legislature has served town rights? What?
Yeah,
Never make a statement like that.
Crazy.
Yeah.
I want to tell you how many times I've yelled it in my last position.
Thank you for asking, us to be here, Ted Brady from the executive, from the Vermont League of Cities and Towns. So, I think the section 8 amending, requiring municipalities to accept the Department of Taxes valuation of public utility, of utility infrastructure, does pose some concerns. It is a big change to the way we do it now, but I also want to acknowledge, I think there are a lot of towns out there that would be okay with that. And a lot of towns that look to PBR for that expertise and that appreciate having PBR's expertise. I also need to acknowledge there are a lot of towns that don't agree with that.
We've
You've heard
several
from them.
today.
I do think that the legislature this year and last year has taken some actions that really devalue municipalities' contribution to maintaining and establishing the grand list. I think last year's Act 68, which I'll share a letter that I shared with this committee, and Ways and Means and Department of Taxes, which was not responded in writing by anybody, raised concerns about last year's move to create a statewide property valuation system. And directed the Department of Tax to bring back to you a recommendation or a way to create a statewide property valuation system. What you have here is a piece of a statewide property valuation system. And I just want to be clear, I don't think the league is in a position to say like we're supporting this or opposing this because our membership is split on this. But it is another troubling sign that people don't understand that you're getting a lot for very little money, which is there are hundreds of listers out there, and appraisers and municipal officials who are maintaining this grand list, who are collecting your taxes, who have to send them to you whether somebody pays them or not. And it's all on the towns to do that. And it really does not feel like a partnership. Now, the folks at the Department of Taxes, especially PBR, I know they're trying to create this partnership with us on this particular provision. I want to reiterate it. It seems to be welcome to several people. So, and the team there has tried to reduce our concerns and our members' concerns. But I don't think we're in a position to sit here and give you what you asked for there, a firm position.
Relatedly, and not off topic, but to your point that you just raised, I really hope to hear more from the tax commissioner, but your thoughts as well. I am very interested in wanting to see us disambiguate non-homestead property parcel types to be able to have different tax rates. And I would hesitate to want each community to have different standards for coding. Are you comfortable with the direction that I think has been floated multiple times about having a standard statewide consistency in reporting types of non-homestead parcels to be able to consider different taxation policies on those classifications that don't currently exist?
Yeah, well, we looked at PBR to set a standard.
Okay.
And to teach us all to follow that standard. And then participate in this
local distributed system to give you something at a really good value. Yeah.
Okay.
Are there any other provisions in this bill that you'd like me to address
Is
today?
there any other provision in this bill you'd like to address today, since we've got you?
Yeah,
We've got
just,
10 minutes for you.
I can be very
Okay,
quick.
just one.
on section 6 and 7, there's a repeal of some penalty money there that this will have a financial impact on municipalities. I think
Yes.
it's immaterial. I want to be clear, though, that I don't think all of our members think it's immaterial, and
Okay.
clerks and treasurers might have a different opinion, and the Clerks and Treasurers Association might have a different opinion
Okay, so we will invite them in.
for section 6 and 7, and then on section 13, I need to thank this committee again and again for the support you've given to the idea of allowing towns to have the authority to implement local option tax. Section 13 creates a local government revenue working group. Please keep that in. We need help. Municipalities cannot balance all you're asking us to do on a property tax alone, especially given the giant sucking sound that comes from the education fund. So please keep that in there. We really like to bring you some recommendations.
Time to change.
When we first saw this the first day, one thing I put on the table, and I'd love to hear your thoughts. I don't know if it fits squarely with this, but from my years on the city council and looking at how Vermont does trash, I'm wondering if we're missing opportunities for consolidated service. Not saying that we want to bring it to municipalities, but do you see value in enabling or not encouraging, but enabling municipalities to look at municipal trash collection as another revenue source, or is that something you'd rather just not even be part of this mix of discussion?
Oh, God. I absolutely, I think that municipalities should have that authority, and I think there may be some opportunity there. I don't know enough about it. I'm gonna go further than that.
I can remember when the city contracted with one hall, and as the other halls would say, if you lose that contract, you've got all this equipment you're not using. You have to do it in a bigger way. To, and you have to maintain cost control.
We'd welcome that being added to other ways, creative ways to create revenue for municipalities. We looked at it and stuff.
Okay,
Thanks.
thank you. All right. Committee. We've got about, I think we've covered everybody we're supposed to so far. We have Bill Frazier, and I don't know, we mistakenly sent the invitation to Barry Town, which is up in the hill and did not get flooded. So I don't know if we'll hear from Barry City, but this is just, what I told you I thought I might add on here, which is extending the date for the flood abatements. I'm not sure, maybe until this July, but they seem to feel that everybody won't. They're busy getting the houses put back together, that they won't have gotten in their abatement request, so we'll listen to him. Meanwhile, if you want to open the door, get some oxygen and stand up for a few minutes, we'll take a break until 3 o'clock, so